Yes, thank you very much for the invitation. And dear Andres, I always enjoy working with you, as you know, and I only regret that I can't be in person with all of you at this summer school now. But at least it is possible via internet. So can we start the presentation? Oh, I can't get it. Can you start this? Ah, perfect. Now it's perfect. So, yes, my talk will deal with the legal problems of digital platforms from a perspective of regulatory strategies and with special focus on social aspects. For this, it is not enough to take the view of the users and discuss inter alia the right to equal and affordable access and other issues of consumer protection. One should also look at the working conditions in this part of the economy. For details, I will concentrate on the mobility sector. I will only mention in passing the new proposals of the European Commission for a Digital Service Act and the Digital Market Act, because both do not deal so much with such social issues, only a little bit dealing with very big platforms. Yes, first I try to map out some major regulatory challenges and strategies. For this, I look at digital platforms in general, but with special focus on social issues. Secondly, I will take a closer look at the legal developments of the regulation of digital platforms in the mobility sector, with special focus on Germany. And finally, I will try to draw some conclusions, once again on a more general level. This shall particularly include problems of reputational mechanism. I start with regulatory goals and strategies and the case for regulation. According to standard economic wisdom, the most convincing reason for regulatory intervention is the danger of market failure, either because of negative externalities or information asymmetries. However, there's much more than that. For example, structural imbalances of bargaining power also constitute market failure. And of course, all these rationales for regulation overlap. First of all, there is concern that sharing platforms should attain a dominant market position by using the power of network effects. In particular, if they are not only broker, Andres explained this in the beginning. This poses a challenge not only to competition law. As to that, the proposed EU Digital Market Act might bring some, but not total relief. Consumer protection regulation to rectify information asymmetries is an even more challenging issue in the sharing economy. Traditional consumer protection law deals with bipolar transactional relationships between a business and a consumer. In contrast, the platform economy establishes a triangular situation because there are also contracts between the platform and the service providers and between the platform and the users. And of course, there's a contractual relationship between the service provider and the user as well. Very relevant information is located within the algorithm of the platform software and is accessible neither to the service providers nor to the users. Having control both over a myriad of data and over the algorithm gives the platform operator enormous power to nudge both the users and the service providers towards adopting a behavior most favorable to the platform. In this context, for example, surge pricing in transportation is a hotly debated issue. Last but not least, there are server privacy concerns. Digital platforms are in a position to collect much more personal data from both users and service providers than is needed to fulfill their core function of reducing searching costs and facilitating trust. The digital economy also challenges traditional labor law. Such platforms like Uber refer to their drivers as independent contractors, but it is less than clear whether in reality they might better be considered employees. Others, like Moja in Germany, have drivers as real employees. At least the imbalance of power might be similar to traditional employment relationships. As far as people have to make a living by delivering such platform-driven services, they might need regulatory protection against an abuse of power on part of the dominating platform. This includes the service provider's right for being active on different platforms, multi-hosting. So it's necessary to combine different regulatory strategies. Legal scholars and regulatory theory distinguish three modes of regulation: command and control, self-regulation, and, in between, regulated self-regulation, also labeled co-regulation. Self-regulation of the platform providers is the dominant mode of regulation up to the present day. The platforms determine the terms and conditions of their intermediary function and define online and offline standards of behavior both for the service providers and for the customers. Reputation systems with rating and reviews by both customers, sometimes also service providers, are currently the most important form of self-regulation of sharing platforms. If certain conditions are met, self-regulation can be a more flexible and cheaper method of solving the problems than state regulation. However, self-regulation often lacks transparency, we heard about this, and fails to account for the interests of actors other than the platforms themselves. A purely self-regulatory approach risks increasing platform power. Regulation by the state, be it on the European or on the national level, also referred to as command and control, has a bad image if it comes to innovative and dynamic business ideas. The sharing economy is often said to be ill-suited for top-down regulation because the state has limited experience with these new business models and lacks reliable information about the operation, particularly the algorithm of such platforms. Nevertheless, state regulation is called for to secure legal certainty. Strict and stable regulation by the state is best suited to guarantee a level playing field. This makes state law preferable if the matter is not too complex and the public interest in regulation is particularly strong. Regulated self-regulation or co-regulation can combine the advantages of self-regulation and of state regulation. Public authorities may define the objectives to be achieved, giving the platform provider more or less scope for implementation. However, combining both methods of regulation will not work if the gap between the interests involved is too large. As long as the aim to take care for consumer interests and certain public interests is generally in line with the interest of the platform provider to preserve a positive image of his company, elements of state regulation can create incentives to mitigate smaller conflicts. If, however, we have to deal with clear antagonistic interests as in employment law, only strong state regulation will do the job. Now I come to new trends in regulating digital services in the mobility sector, in Germany in particular. New mobility services use, as we all know, an internet platform and a mobile app to connect users and vehicles. Although some of these services are offered by private individuals driving their own vehicle, they are controlled by powerful companies such as Uber, which manage the service via the digital platform and to control the service in economic terms. The ECJ decision has been already mentioned. With these new forms of mobility, the question arises how they can be successfully embedded in a future mobility concept and how legal regulation must be drafted for this purpose. Against this background, I will deal with the discussion in Germany and the very recent, from April, amendment of the German Passenger Transportation Act in particular. As in some other countries, German courts have repeatedly rejected various Uber mobility services as incompatible with applicable law in the past years. This points to some special features of the German Passenger Transportation Act. Only transport services that fall into one of the categories specified in the Act may be offered. The types of transport are on the one hand regular services that have fixed departure times and stops, and on the other hand occasional services, which operate depending on individual demand. At first glance, app-based mobility services can be classified as occasional services. However, they do not exactly fit into this predefined category because collecting different passengers with a similar destination is generally reserved for regular services. Within occasional services, there are further subcategories: taxi services and chauffeur services. For the purpose of consumer protection, taxi services are particularly strictly regulated. There's an obligation to carry. Therefore, passengers may not be rejected, for example, because a route seems too short or because the pickup point is too remote. Transport charges and conditions are prescribed by the authorities. Also, the licensing authority may limit the number of taxi licenses in order to protect the local taxi industry. Many, but by far not all, German cities make use of this opportunity. Uber and others operate outside the local taxi contingents. Their attractiveness is not least due to lower fares in comparison to traditional taxis. It is obvious that this can jeopardize the profitability and thus the functionality of traditional taxi services. The question, however, is whether, in view of new ride-sharing opportunities, the taxi industry in its traditional structure still plays such a central role in guaranteeing urban mobility as it once did. Chauffeur services, in turn, are subject to other specific restrictions, which distinguish this type of traffic from the taxi industry. As to that, the so-called obligation to return is especially important. If there is no immediate follow-up order, they must return to the company headquarters after completing a journey, while taxis can wait at various taxi stands. Also, orders must be placed via the chauffeur company. A direct placing of orders to the driver via app or by hailing a car on the road is inadmissible. Finally, transporting additional passengers en route, so-called pooling, is prohibited for chauffeur services. Taken in isolation, all these restrictions appear absurd. However, otherwise chauffeur services, which are not subject to any transport obligation and, above all, no prescribed tariffs, would threaten to displace taxi services, which are more heavily regulated in this respect. Almost all of the regulation described fulfill a legitimate purpose in the current system by assigning and safeguarding the classical types of public mobility their place in a largely harmoniously divided transport market. Every category and every subcategory has a specific role to play in satisfying public transport needs. Regular services provide a standardized timetable for the transport of larger numbers of passengers. Taxi services provide more individualized transport, especially for the elderly, the sick, and business travelers, and close the gaps in the services offered by buses and trains. And last but not least, chauffeur services provide particularly exclusive individual transport, especially if it goes beyond a single route. The public service duties tailor-made for the individual types of transport are also matched in the system by tailor-made revenue generation possibilities in certain market niches. Altogether, this is based on the still valid consideration that local transport is a public service. In European terms, a service of general economic interest pursuant to Article 14 TFEU. It is assumed that the free market alone will not produce a comprehensive supply at affordable prices. This regulatory regime of well-balanced role allocation is shaken to its foundation. New atypical mobility services which do not equally balance burdens and market opportunities appear. Furthermore, the classic objectives of services of general interests are today being supplemented by increasingly urgent environmental and climate protection requirements. A future-oriented regulatory regime must therefore take into account the interlocking and partial substitutability of the various modes of transport, including individual transport and at the same time even bicycle and electric scooter transport. The former strict regulatory concept was not sufficiently open to development. It was not suitable to channel ride-sharing in such a way that it can develop its potential for a sustainable urban mobility concept. Now, the recent reform of the Passenger Transportation Act does solve some, but not all of the problems outlined before. Firstly, it has now been made explicitly clear that digital platforms for transport services are subject to the Passenger Transportation Act. This is the precondition for applying the obligation to carry and to regulate their terms and conditions. However, digital platforms only need to be licensed under the Act when they can be considered a service provider themselves, not only a broker. I refer to Andres in the beginning. This is the case when they effectively control the services and the actual drivers are left with only a limited scope of action, as it is the case, I think, with all these services now. Secondly, and most importantly, there are new regulations on ride-pooling services. The idea of distinguishing between certain predefined categories of traffic services has been maintained, as well as the existing distinction between regular services and occasional services. However, the amended Act assigns ride-pooling services now to both categories. Two types of ride-sharing or pooling services are now classified differently. On the one hand, pooling services which operate on demand but within a network of fixed stops can be classified and regulated as a new type of regular transport and shall serve as a demand-driven supplement to the classic scheduled services. These supplemental ride-pooling services will also be subject to the obligation to carry and to terms and conditions prescribed for regular public transport. On the other hand, other ride-sharing and pooling offers are now classified and licensed as a new subcategory of occasional services, occasional traffic, called occasional pooling services. It is essential for such services to be offered entirely freely on the market, in German terms, self-sustaining, without being burdened with public service obligations. This unplanned free provision of ride-sharing services where, via app and internet platform, supply and demand come together in individual cases, corresponds mostly to the business models of the currently predominant providers such as Uber, Moja, and others. However, there is a danger that such an unleashed new subsector will economically displace other important traffic services. Authorization for such a pooling service will therefore be refused if it cannibalizes certain public transport services. Economically, one speaks of cream skimming, and thus threatens the economic viability of the local public transport with buses and trains as a whole. Additionally, there are certain requirements for such free pooling services meant to protect the taxi industry. For example, they do not enjoy similar privilege under road traffic law. And to mitigate competitive disadvantages for taxi services whose terms and conditions are strictly regulated, and to maintain price advantages of regular traffic services, the competent authorities may dictate even minimum rates for new pooling services. In view of the experience with low-paid drivers at Uber and similar platforms, the amended Passenger Transportation Act states that social standards for the protection of employees can be made obligatory by the competent authority, and even for the occasional pooling services too. The EU Regulation 1370 from 2007 so far only provides for this in connection with public service obligations in public service contracts, but does not prevent further reaching national regulation. The environmental dimension, in particular the necessity to fight climate change, is also expressed in various new provisions of the Passenger Transportation Act. I will go not into more detail here because that's not my main topic today. Furthermore, the agency must, without discretion, set a minimum pooling rate in order to both mitigate the volume of traffic for ecological reasons and to distinguish such services from conventional taxi service with purely individual transportation. But further reforms are needed to ensure that the state meets its responsibility to guarantee sustainable urban mobility in the future. Here I will single out only one issue. Without a planning basis, there can be no demand-oriented and environmentally compatible urban mobility. This is particularly true for public services, which rely on subsidies. Only planning can give the city an idea of what is needed and, on this basis, of the concrete transport services that it should buy from transport companies in public service contracts. As already mentioned, this can also apply to ride pooling services if they are intended to systematically supplement or even replace local public transport and therefore do not appear economically viable. But the need for planning goes beyond this because it is necessary to reduce individual transport in cities for environmental and climate protection reasons and because of congestion problems. Against this background, almost all German federal states have local transport laws in which the local authorities are obliged to draw up local transport plans. However, laws and local transport plans concentrate almost exclusively on public transport with buses and underground trains now. The Passenger Transportation Act already calls for an integration of transport services across different means of transport in the respective local transport plan. Accordingly, some local transport plans increasingly focus on mobility chains, for example, in the form of park and ride and bike and ride. However, the perspective must be extended to all forms of transport, which must be networked to form an overall transport concept. The local transport laws should therefore be amended in such a way that ride-sharing and ride-pooling services are also included in their complementary function for local public transport. This leads me to some general conclusions and first, challenges and regulatory approaches. By far not all insights derived from the mobility sector can be generalized. However, with a view to social issues, some challenges and regulatory approaches can to some degree be found in other sectors of the sharing economy too. As is the case in much of administrative law, requiring prior authorization of such platform services can help to address problematic issues, even social ones, proactively and allow for a more effective enforcement of the existing regulations. As far as platform-driven services are services of general economic interest, a stricter regulatory framework might be needed. This may concern terms and conditions. As can be seen from media platforms such as Facebook, this might also concern the need to guarantee a certain plurality of content. Looking at the mobility sector shows that such a need for regulation may well be limited to certain concrete services. Different services, even within the same platform, may hence require a different intensity of regulation, depending on how essential the provided services are. Equal and affordable access to such services becomes very important in the digital platform economy. As to that, it will depend on the specific circumstances, whether general anti-discrimination law will suffice or special provisions are required. For example, regarding terms and conditions or an obligation to carry, as can be found in the Passenger Transportation Act. Particularly strict regulation so far is required for media platforms, including social media, because of their essential role in the democratic process. The growing market power of such platforms makes their user appear in particular need of protection. On the one hand, with regard to the users of the platform itself, this is a matter of consumer protection. I will discuss this in more detail with a view to the reputation system of such platforms. On the other hand, I think that's a very important lesson from the mobility sector. It has to be ensured that such platform services do not displace existing public services without adequately replacing them. In the mobility sector, this is being discussed for the traditional taxi services. In the case of media platforms, it is public broadcasting services. And with Airbnb, it is traditional rental apartments. Reputational mechanisms with numerical ratings and qualitative reviews are essential for the functioning of the platform economy. Such systems are a major means to build trust. We all have heard this from the last talk, and shall serve as equivalent safeguards for the shortcomings of traditional consumer protection. Up to now, the reputation mechanism is within the platform's responsibility alone. Pure self-regulation. The management of the system and the underlying algorithm basically remain a black box. It is not clear whether and under which circumstances platforms delete reviews because they are judged to be impertinent or offending. We do not even know whether the platform eliminates some user-generated ratings due to statistical or other reasons when calculating the average rating or when compiling a statistic summary on a service provider. A growing number of articles in the field of behavioral economics and psychology cast some doubt on the validity of such rating systems. Many existing review platforms have been shown to generate implausible distribution of ratings. The literature has linked this abundance of positive reviews on online platforms to at least 4 underlying phenomena. Herding behavior, whereby prior ratings subtly bias the evaluation of subsequent reviewers. Underreporting of negative experiences because reviewers fear retaliatory negative reviews on platforms that allow and encourage two-sided reviewing. Self-selection, where consumers who a priori are more attracted to a service are also more likely to use and review it. And, most problematic, strategic manipulation of reviews undertaken by firms who seek to artificially brush up their online image. And social bots might offer further opportunities to manipulate a competitor's average rating on a large scale. We also all heard about the AI proposal. It is questionable whether the economic self-interest of the platform provider will lead to sufficient measures to improve the reputational system. So we should not exclusively rely on self-regulation to guarantee a functional reputational mechanism. There is a need to safeguard consumer and public interest. As to that, one can think of at least 4 different means for regulating the platform's rating and review system. First, sharing platforms could be ordered to provide detailed information about their rating mechanism for public authorities. Admittedly, disclosing internal operations of such software affects elemental business secrets of the sharing company. Precautionary measures must be taken to guarantee that only the state agency and under no circumstances competitors get to know the algorithm. Secondly, the law should set minimal standards that the reputational mechanism has to meet, and so on. I have to skip this. This should enable consumers and contractors to better judge the validity of the rating system and to better correct for inherent biases. Thirdly, the platform must face the duty to delete or even correct wrong data within its reputation system on a notice and take down basis. This is already the law under the General Data Protection Regulation as far as personal data is affected, and for some part also under the e-commerce directive. Fourthly, the provider of the sharing platform could also be forced to monitor the functioning of its rating system with the goal to detect manipulation from third parties. However, such a duty would only be compatible with the e-commerce directive as far as in the reputation system the platform is not limited to a passive role of hosting reviews, not mere broker. It's not entirely clear whether this would change under the draft of a EU Digital Service Act. So that's my end. Of course, we are not at the end of the development towards the platform economy. Therefore, we are also far from having reached the end of debates about the need for legal regulation to cope with these economic developments. Thank you for your attention.
So, thank you very much, Professor Fehling, for this wonderful presentation. And now we have 5 minutes for the discussion. Do you have any question? Do you have any question?
I have one.
Yeah.
If not, so Professor Fehling, if no one wants to ask you anything, which is maybe normal because the exposition was really clear and it covered almost everything, I would take advantage of that possibility, and it's more a prospective question than something related to the exposition. My question would be, do you consider that disintermediation by digital platforms and also the offering of service directly by some of these platforms in some cases presents any problems in terms of market efficiency or market disruption or market failures, or all the problems that we can see are not related to market questions, but with the conflict of market efficiency with some other social values? And in that case, the regulation should have to be a little different, because it should be aimed at trying to obtain a proper balance of these two values in conflict, market and other social values. Many thanks.
Of course, I think there has to be a proper balance between market efficiency and other values. I try to map this out as the more it is close to a service of general interest, then the higher the regulatory intensity might be. So that's maybe a special feature of the mobility sector, but not only, because in the media we also have this idea. And the second issue is, if there are other services in the real world which might be replaced by digital services, then that might be an issue as well. And I think that's an issue with Airbnb, because Airbnb apartments displace the classical rental apartment market in many cities. And that's also a big concern for regulation. So in the end, I think digital platforms will help us to deliver many services more efficiently than in the past, but only if they are given a proper role within other services, and this has to be done to some extent or another by public regulation as well. Only self-regulation is not enough.
Okay, thank you. More questions? No? So we are, thank you very much, Professor Fehling, for the discussion.